A single federal judge can block a federal policy nationwide. The Supreme Court has grown increasingly skeptical of that power. But it has also suggested something important in its place: class actions. Understanding the difference matters. Much of the current debate focuses on nationwide injunctions, court orders that prohibit enforcement of a law or executive action against everyone, everywhere. The court's concern is not simply about outcomes. It's about remedial authority, who is before the court, and how far relief can extend. That's where class actions enter the analysis. A nationwide injunction is typically issued by a federal trial court and extends relief beyond the parties to the case. Instead of protecting only the plaintiff, it binds the government as to non-parties, often prior to appellate review. Historically, that was unusual. Federal courts traditionally resolved concrete disputes and tailored remedies to the parties properly before them. Nationwide injunctions depart from that tradition. The Supreme Court has repeatedly signaled discomfort with the scope of nationwide injunctions. In Trump v. Hawaii, Justice Thomas warned that such injunctions appear to be inconsistent with long-standing limits on equitable relief. The concern is not whether courts can declare law unconstitutional. They can. The concern is whether a single district judge should effectively set national policy through remedies. A class action operates very differently. Under Rule 23 of the Federal Rules of Civil Procedure, a court may certify a class only if strict requirements are met, including commonality, typicality, adequacy of representation, and in most cases, notice to the class members. Once a class is certified, every member of the class is before the court. That jurisdictional difference is critical. When a court issues class-wide relief, it's not extending remedies to strangers. It is protecting parties who are properly before the court and who are bound by the judgment. That is why the Supreme Court has suggested that class actions may be constitutionally sound alternatives to nationwide injunctions. Broad relief is still possible, but it is anchored to jurisdiction and procedure, not judicial discretion alone. The distinction matters because many modern constitutional challenges involve policies that affect large groups of people. The question is not whether courts should be powerless. It is how power should be exercised. Class actions preserve judicial review, appellate structure, and separation of powers. Nationwide injunctions often short-circuit those safeguards. If the Supreme Court limits nationwide injunctions, it does not eliminate constitutional litigation. It redirects it toward procedures that ensure courts act only for parties properly before them. That shift would reshape remedies across administrative law, immigration, healthcare, and beyond. The debate over nationwide injunctions is not about who should win a particular case. It is about how constitutional disputes are resolved and how far judicial remedies may extend. Class action may prove to be the court's answer.